Okay, Chapter 8, Part 3. Go through a couple of these slides quickly because I don't think that they're of great significance. This has to do with the World Trade Organization, of which the United States is a member, and we had to modify our laws to comply with those World Trade Organization laws regarding patents and increase the time for a valid patent. Again, the time runs from the date of filing, not from issuance. And we are the first to invent rule rather than the first to file. So that changes that a little bit. Okay, so the American Inventors Protection Act reorganized the Patent and Trademark Office in these ways. And you can look at those. Now here are some important factors. A patent cannot be sought if the invention has been in use for over a year prior to application. So if you invent something and you allow people to use it, say you want to test it or whatever, if you don't patent it within a year, you lose your possibility of getting protection. And that's the purpose right here of doing that. All right, so that brings us up to the next type of intellectual property. So we've talked about trademarks, and we talked about patents, and now we're talking about copyrights. So copyright is an intangible property right granted by the federal statute to the author of the original of a literary or artistic production of a specified type. When the copyright is over, we say that the product enters the public domain, which means anybody can use it without having any penalty or being guilty of any infringement. So before 1978, you had to register your copyright in order to get protection. And this is something that I think people don't realize. Even though it happened a while ago, people still think that to be protected you have to register it. No, all you have to do is note it and be able to prove that it was in use prior to whoever is infringing on your copyright. So after 1978, works are automatically given statutory copyright protection for the life of the author plus 7 years. That's a long time. For publishing houses, it expires 95 years from the date of publication or 120 years from the date of creation. It's a long time. Following the expiration, it enters in the public domain, and as I said, you don't have to seek permission or pay a license. Now, you still can register a copyright if you want to. Okay, the value in doing so is what? The value in doing so is if somebody infringes on your copyrighted material and you want to sue them or you want to stop them, you have to prove that you had invented that thing before the other person did. And one way of doing that is registration. Okay, so if you register your copyrighted material in 2019, and now you're suing somebody for infringing upon that, and they go to court and show that they published that same thing in January of 2020, even though they may allege a copyright, they're going to lose because you've got proof that you did it before them because you registered it. And so you'd be protected against reproduction of the work, development of a derivative work, distribution of the work, or public display of the work. To be protected, it must be fixed in a durable medium. We said protection is automatic, not required. So some of the things that can be copyrighted: literary works, musical works, dramatic works and accompanying music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, including multimedia, sound recordings, and architectural works. If it's not original, it's not going to be protected. Only the expression can be protected, not the idea itself. Compilation of facts can be copyrightable, but they have to be original. If you use somebody else's copyrighted material in a substantial way, you can be guilty of infringement, and remedies can apply. And those remedies include any profits that were made from that, any personal damages like reputation or loss of exclusivity. The court can order destruction of that infringing material, can order an injunction against that person from using it, and can award statutory damages up to $100,000 for willful violations. Okay, now, the difference in the copyright and patents, remember, with a patent, you can give a license to somebody to use your patent. With a copyright, you could probably do the same thing because it's a contractual arrangement, but there's also some common exceptions to copyright. So there is no infringement if you're using the material for criticism, comment, news reporting, teaching, scholarship, or research. These are called fair use. These guidelines are very broad, and the courts determine it on a case-by-case basis. So I think in colleges now, I know that when I was at Athens Tech, we had an introductory course for all students. It was called First Year College or something like that. And in that course, they incorporate a portion of discussing copyright law, because that's one of the things that professors especially get upset about when students violate copyright law, when they write a paper that takes from somebody else's copyrighted material, usually something that a professor has written and published. So we want people not to do that, to make sure that they meet either the fair use exception to that. Okay. These are the factors that courts are going to use in judging whether it falls within fair use. Is the character of it more of an educational or a philanthropic type of use, or is it for non-educational commercial purposes? Obviously, the more commercial it is, the more likelihood that you're infringing on that copyright. The nature of the copyright work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So if you're copying a couple pages out of a 600-page textbook, it's unlikely to be a violation because it's such a small part. The effect of the use upon the potential market or value of the copyrighted work. Okay. The first sale doctrine is once a copyright owner sells or gives away a particular copy of work, the copyright owner no longer has the right to control the distribution of that copy. So if you buy a textbook, okay, that is like a license. However, it is basically transferable, meaning you can resell that book without violating the copyright law. Software, it applies to software as well. In terms of certain particular statutes that also apply. The Computer Software Copyright Act, the Judicial Improvement Act, the Semiconductor Chip Protection Act, and the Digital Millennium Copyright Act. So those are some other protections in that area. So for software, the copyright generally extends to parts of a program that can be read by humans, the binary language object code, and the overall structure, sequence, and organization of a program. Courts don't usually apply a copyright to the look and feel of a program. There's a fair use doctrine here as well. A quotation used for review or criticism in a scholarly or technical work is protected fair use. A parody or satire is protected fair use. A brief quotation in the news report, newsreel, or broadcast of an event is protected fair use. A small portion reproduced by a teacher or student to illustrate a lesson is protected. And anything used in a legislative or judicial proceeding is protected. Okay, so that completes the discussion of copyright law. We're going to stop there with that part 3, I believe, and we're going to go on to part 4. Again, the magic word for chapter 8 is patent.